Welcome to the EB-5 visa retrogression webinar here. We're about to go through what is likely to happen over the next year with retrogression based on the data that we have received. There's been a lot of things that have come out recently, including a FOIA from AIIA, the American Immigrant Investor Alliance, that gave us a lot of clarity on the amount of petitions filed. And then also the USCIS's warning on the January visa bulletin that there likely will be a backlog here at some point, a priority date shown at some point in the 2025 fiscal year, which ends September 30th of this year. And we'll be walking through this again. If you didn't hear this earlier, if you have questions at the end, you can use the Q&A. We're hoping that we're going to answer the majority of your questions throughout the webinar. And let's go ahead and start. I myself am Brennan Sim. I have been working in the EB-5 industry for the past 12 years. I'm with EB-5 United. We've been one of the largest groups in the industry in recent years. And here throughout the presentation, if you want to take down my information, I manage our sales team at EB-5 United, and we have representatives all throughout the world. And if you have interest in some of our projects, then you feel free to reach out and I'll get you connected with a representative that serves your area. We like to get out. We have guys in India. We have guys that travel to the Bay Area, Seattle a lot, all throughout the US for people on H-1Bs. And then I'll turn it over to Niral Patel, who's a immigration attorney with KLDP.
Thanks, Brennan, and thanks for inviting us here. So I'm a partner at KLDP LLP. We're a full-service immigration firm, but we specialize in EB-5. I've been doing EB-5 for almost, I think, 10 years now. And, our clients have seen the entire life cycle of that EB-5 program. And we have offices in New York and LA.
We're also joined by Phoung Lee.
Yeah, thanks for having us, Brennan. Always good to see you guys. I'm Phoung Lee. I am one of the EB-5 partners at KLDP as well. It makes me feel old saying this, but I've been doing EB-5 for almost 18 years now. After going through a lot of these deal cycles, working with thousands of investors throughout the years, we get certain insights and certain things that, we'd like to share with our investors to make their life a little bit less stressful. So hopefully that's what we'll do here today as well.
All right, great. And I think after the issues that we went through with the backlog throughout 2015, 16, 17, 18 between China and India, it also gives us a little bit more clarity on how to make assumptions based off the data that we've been able to receive here recently. So let's go ahead and jump right in to what retrogression is, what the visa bulletin is, and how this is likely to play out over the next couple of years. So I want to start with just the visa bulletin right here. So this is, if you're going onto the USCIS website, you look up the visa bulletin, you are going to see something like this where you're seeing the 5th unreserved category. That is for investors that filed an I-526 petition before the RIA, or for new I-526E petitioners that are not from India or China, they can obtain one of those visas. And you can see people outside of India and China are all current. They have a C there in their category. Now, China and India both have backlogs to July 15th of 2016 and January 1st of 2022. So that's for petitioners that filed before the RIA, or if they were to file in a non-TEA today, they would still go into that category because the TEAs then have the set-asides. So you see this 5th set-aside for rural, that's 20% of the visas, and you see that is current in every country. And you see the 5th set-aside for EB-5 in the high employment, that is current for everyone across the board, as well as infrastructure. Now, what the USCIS said on the last visa bulletin is that they are anticipating that some of these squares here in this chart under the set-aside categories are going to show a priority date by the end of this fiscal year, which ends September 30th of 2025. That will be the end of the 2025 fiscal year. So whether that will be a backlog, a priority date shown for Chinese-born or for Indian-born applicants, we don't know, or it may be both. We would anticipate China would be first and then India. And whether that will show up for rural or high unemployment first, we don't know. Now, we will see in the data, there are more filings in high unemployment and less visas available. So there will be a longer backlog in high unemployment, but whether that shows up on the chart first or not depends on how many petitions are approved. And the petitions are being approved more quickly for rural projects. So we'll get into that a little bit more here in just a bit as to where this is going to show up first. We just don't know. So what is that going to mean for an EB-5 petitioner? Well, if we look at the current backlogs that there are for India and China for past investors, if you filed a petition, let's say in November of 2019, there was a lot of petitions filed at that time, and you are born in India and you have your I-526 approved, you can look at the date here and you know that you filed your petition in November of 2019, and that is before January of 2022. So you can obtain a green card right away. It is available. If you filed that same petition after January 1st of 2022, you would have to wait until your priority date is current here. If you were Chinese and you filed in November of 2019, then even if you have an I-526 approval, you would be unable to obtain a green card right now because you would have had to file before July 15th of 2016. And so the priority date is the date set that you had to file before that date in order to be able to obtain a green card once you have your I-526E approved. Going forward, the other big issue that gets involved here is that priority date can also prevent you from concurrent filing. And for the majority of the people that are on this webinar, a lot are H-1B workers or F-1 students that are here in the United States. And that can cause a problem for Indian and Chinese investors. Now, there is also something called Chart B. If that one is current and allowing for filing that current month, then you could have a backlog on Chart A, but be current on Chart B and still be able to concurrent file. However, if they're not allowing filings off Chart B in that month, then you may have to wait. So what this means is that for people that are in the United States now that are looking to file a petition and concurrent file to both lock in your child's age or to be able to get that work authorization and advanced parole travel permit while you're waiting for the green card, the availability to do that may be going away here at some point between now and September. And so that is going to cause a lot of people to want to file very quickly. So I just want to throw this to Phoung and Niral a little bit. That will also cause a huge rush of people trying to do two things. One, probably put in a partial investment and file a petition as soon as possible. But also it's going to drive a ton of people to wanting to file as quickly as possible, which is going to take up the time of the majority of the immigration attorneys in this program. So I guess what recommendations do you have for clients right now that are looking to file as quickly as possible?
So first of all, Brennan, I'm glad you shared this chart right now. I think everyone who's on this webinar participating, you should absolutely bookmark the Department of State Visa Bulletin. It's something you should be checking absolutely every month, and they release it about 3 weeks in advance so you have an idea of what the next month's priority date lists are going to be. I think practically speaking, our job, Phoung and I, it's never to rush anyone into EB-5. It's a big financial commitment. But at the same time, if it's a decision that you've made to move forward with and you have the financial means to do it, understanding that there could potentially be a backlog, it just makes practical sense to do this sooner rather than later. Just because you can at least get the AP EAD, which is good for 5 years and which you can renew forever after that, no matter what the backlog looks like. And for those of you who have children approaching the age of 21, you're able to lock their age in right now.
Could you expand on that a little bit about aging out? Because that is something that comes back into play once we have a priority date here. So let's say I have a child who is 18 years old and I want to file right now. And if I can get in and concurrent file, what happens? But if I can't concurrent file, then what are the risks in the future for my child?
Sure. So everyone knows that an EB-5 petition or any green card petition includes spouses and children under the age of 21. And as long as you file for that child under the age of 21, their age will be frozen in time until that immigrant petition, in this case, it's the I-526E, is approved. So in order to, once that petition is approved, then the age is unfrozen and the clock starts to tick again on that child's age. And the only way to lock it back in is to file an I-485 if you're inside the US, or to pay the visa fee bill if you're outside the US. Those two things can only be done if a visa is available, which means your priority date is current. Either it says C or you filed on or before the priority date cutoff. So assuming you have a child who's 20, let's just say 18 or 19 years old, and you filed in the month of January and you're Indian born, then at least you're able to file the I-526E and the 485 concurrently, basically two almost triggering events to lock in a child's age. You're able to do that concurrently and secure that child's age almost no matter how long the process takes after that.
And I think that's a big deal because this question pops up a lot, right? Pre-RA, people be worried like, if my child is 18 or 19 or 20, is it too late to file for them? How do I know that I'll go through EB-5 and that my child will be safe? It doesn't make sense for my family to invest all this money and then one kid gets left behind, right? Under the RA now, the fact that you have concurrent filing, which is such a powerful tool for so many people, if you basically just, instead of trying to run all these projections, all these numbers and everything else, like if you know your child is close to aging out, if you know that there's a possibility of a backlog, you can simply take matters in your own hand. If you concurrently file, you essentially stop their age, throw away the clock, and your child will be safe, right? So it's a very practical and easy thing to do to take care of your family.
And one more question for you guys, just to get clarity for everyone here. Once we start to see a priority date, as long as you file before that, you'll be able to concurrent file. Once we see a priority date on chart A, and let's say chart B is not available, we know then that we cannot concurrent file. But what happens if I file a petition, I can't concurrent file, but then chart B becomes available and my priority date on there is either current or before the date that's posted? Can I then concurrent file after I've already filed my 526E petition?
Yes. So as long as chart B is open for filing, and again, I tell everyone, look at the State Department visa bulletin, and there'll be a link there that takes you to a USCIS website that basically runs through month by month on when chart B is available. You don't really find out until you're in a particular month, but it's good to know because even if chart A has retrogressed and USCIS opens up chart B, the priority dates under chart B are oftentimes moving a little bit more quickly, which means that you can still, as long as your priority date is current according to chart B and chart B is open for filing, then you can get your AOS application in. Your 485 is still going to be determined by the chart A priority date, but it allows you to get that AP EAD processing so that you can move off of F1 or H1B or whatever it is that you want to do.
All right. And we see a question about what is chart B. When you go onto the visa bulletin, you'll see two charts on there. The final action dates, and what's the other one called?
Dates of filing.
Dates for filing. So those are the two charts. Sometimes chart B is available, sometimes it's not. So after the chart A retrogresses, there will be months that all of a sudden people who have filed their I-526E petition will be able to send in a concurrent filing even after they already have filed. So it's not as if concurrent filing will go away completely, but the availability of it varies month to month, and your priority date would have to be concurrent on chart B for you to be able to send in that I-485 application and then get the EAD and work authorization. So this is huge. I think this is the basics of what you need to be able to look at and understand. But now I'm going to get into kind of why we call it the silent backlog. Because we already know, especially for the high unemployment category here, we already know that there is a backlog. If you file now, you're likely going to see a backlog, even though the chart says current right now. Rural, it's right on the cusp of that. We're right on you don't know if you would have a backlog or not, because I want to go through the supply and demand and explain this. This year, you can see up here in kind of the upper right, there's 4,274 visas available for rural projects this fiscal year until September 30th. There's 2,137 in high unemployment and 427 for infrastructure. So that is the supply of what we have for fiscal year 2025. And if we go, the reason why we have that much supply is in a normal year, a normal fiscal year, there's 9,940 visas available for EB-5. So you can see in 2025, that's what we had. All right. 32% of that is this 3,181 visas that got added to the 3 set-aside categories. So about 2,000 in rural, about 1,000 in high unemployment, and the rest for infrastructure, around 200 for infrastructure. Those we also add with 3,658 visas that were in the reserve categories last year, but did not get used. And so those all rolled in this year to the set aside. So we have some extra visas because throughout COVID, a lot of consulates were shut down. There were extra visas over the past few years that were not used that came into EB-5. So we had extra visas. So this year there's 6,839 visas available, of which 4,274 for the rural, 2,137 for urban high unemployment. Now, this 3,658 visas, if those are not all used this year, the set-aside categories will lose whatever's left over to the unreserved category here for next year in fiscal year 2026. So it's very important that USCIS issues as many visas as possible this year by September 30th, because if they don't utilize all 3,658 of these visas that rolled over from last year, it's only going to be replaced with another 3,181 next year. So we lose about 500 visas that just won't get it. And plus extra, all these visas just get lost to the unreserved category. So they'll go to EB-5 petitioners, but not to the set-asides. What that means, that is also going to impact how long a potential backlog would be. So people are asking, what are the predictions on a potential backlog? It's very difficult to say because you have to look at how many people get approved, and then you have to look at how many visas are available and how many of these visas get issued this year before we get a new set of visas next year. Because if we lose visas out of this category, they'll be lost forever, and that will slow down the set-aside categories. This year, I do expect for them to utilize the majority of the rural visas, as those have been being adjudicated very, very quickly. But a lot of the high unemployment will likely get lost because those petitions are taking quite a bit more time to be adjudicated. And you see with the number of filings over the past couple years since the RIA, we've had from China about 100 more in high unemployment than we have in rural. So 1842 in high unemployment, 1771 in rural. In India, we've had 685 filings in high unemployment, 478 in rural. So these are the two countries that are looking at the backlog. And you can see there's a few hundred more filings in high unemployment than rural, but there are double the amount of rural visas available than there are high unemployment. So you can see that there will clearly be a backlog coming once more of these high unemployment petitions are approved. Now, if you look at these numbers, you have to multiply the amount of filings by about 2.5, because every filing is usually about 2.5 visas. So if you have a filer, their spouse, and they have 3 kids, that's 5 visas. If you have a single filer that's a student, that's 1 visa. So the average is usually about 2.5. So if we're looking at the demand, this is the most important chart as far as looking at how long would a backlog be. Right now, the demand for rural visas, this is from IIUSA, somewhere close to 5,400 visas that they need. Now, there are up to that number. There are 4,274 available this fiscal year through September. And then if you look into the next year, there's 6,262. So there really is enough visas to kind of take on that load right now. But as we are continuing to file petitions, that the demand will soon outpace that supply. That is why we are right on the cusp of if you file right now in a rural project, you might not see a backlog. There's a potential maybe you do see a wait for a year or so. It's very close to the point where we will potentially see a backlog. But as far as a priority date, that would be probably sometime between now and the end of September that they will post a priority date. Now, for high unemployment, you can see the demand is somewhere close up to 8,158 visas, right? Now, not all of those are from India and China. So let's say we deduct that a bit. But over the next 2 years, there's only about 3,131 visas available. So you can see there's already a couple years of a backlog piled up here in the high unemployment category. How many years? That's really hard to say because it's not just a rigid number, and it depends on how quickly petitions get approved, how many of the visas are used this year, how many of those are issued this year, because we'll lose some of those to the unreserved category next year. And there's a lot of different factors, but you can see it looks for China and India like it would already take a couple more years, because there will only be about 1,000 visas added to this every year. There's already multiple years that you would have a backlog here in the high unemployment category. Now, rural still could show up with a priority date before high unemployment. This is a very tricky thing, but that is because there has already been 478 approvals for rural I-526E petitions, even though they've filed, that's more than double the 240 approvals for high unemployment, even though there has been more high unemployment filings than there has been for rural filings. So the way that the USCIS puts these priority dates onto the visa bulletin is they look at how many petitioners have been approved and are waiting for a visa. So we might even get to a point where even though the high unemployment is already backlogged, what is appearing to be a few years, and rural is right on the cusp of backlogging, we could still see a priority date in rural prior to the high unemployment category just because of the amount of visas or I-526Es that are being approved in rural projects. And you see with this, that's showing the visa demand. They used a multiplier, of about 965 in rural, and 338 today from China, and 338 from India for these rural visas, which they have 62 over the next 2 years. For urban, you can see there's not enough demand yet that's been approved in either of the categories to show a priority date on the visa bulletin. So that's a lot to explain that. I guess, Niral and Phoung, do you have anything you want to add to what these numbers are telling you?
We're lawyers, not mathematicians, so we leave that to you, Brennan.
Okay.
Yeah.
But I mean, I think overall, you're absolutely correct, right? I mean, I think as practitioners, we see this day in and day out, considering how long the three of us have actually done this. And that's what the green card process in the US is built on, is demand and supply. And with such a popular visa, and I think with the improvements they made on the RAA, it was natural that at some point demand was going to exceed supply, which is exactly when retrogression kicks in. So exactly, like you said, exactly when we'll see it, hard to really tell, right? We don't have a crystal ball. But I think some of our advice to investors always is, you've got to make peace with certain things when it comes to US immigration. And especially if you are going to partake in EB-5 or under the other EB categories, is USCIS processing. I think they've improved, but it's always a little bit of a sliding scale. And then B, the later to go through this process, you've got to make peace with the fact that you may get caught up in retrogression. But at the same time, and I think what we'll talk about next, is that it's not the end of the world.
And I think part of it is, we're attorneys, don't trust our math. But I think our analysis is pretty helpful for you guys, right? I look at this data, and for me, I don't spend my time trying to forecast when a possible backlog will occur. I think what it does is it gives me data to kind of figure out what decisions should I make now. What's clear from this is that, like Niral said, demand is certainly catching up to supply. And with what we have with this roll ban right here is it's funny because this is year 3 or 4 of the RIA, and we think 2025 is when it really becomes popular and when it really takes off. So I think it's no surprise that even for rural, it's close to extinguishing the number of available visas. And now you can almost certainly, just from having seen these other rushes and backlogs that have occurred in the past, as people get closer and closer to getting more data to understand that there's a backlog, there's going to be a massive rush and there would be a spike. So I think with all that in mind, I think it makes sense that if you are interested in EB-5, that you take proactive steps now, work on your source of funds, start trying to figure out what to do. So you can prepare to act before any backlog occurs.
All right. Well, this is a question for you guys as attorneys, just for understanding for people so that they understand where the backlog comes into play in this process. So this is showing the source, starting from the source of funds, going to filing the I-526E petition. If you're in the US, you do adjustment of status. If you're outside, you are going through your DS-260 and then getting the conditional green card. Where does this backlog come into play? When am I impacted by not having a current priority date? So
there's really going to be, we'll talk about the adjustment of status filers first. There's really going to be 2 times that this visa bulletin and retrogression is going to be important to you. The first time is at the time of filing your I-526E and your adjustment of status concurrently. At that time, you look at the visa bulletin. As long as it's current, then you can at least apply for the adjustment of status and get your AP, EAD processing right away. The second time you're going to look at the visa bulletin is once your I-526E petition has been approved. Once it's been approved, you look at the visa bulletin at that point in time, and as long as your priority date is current, then USCIS will pull your 485 off the shelf and start to process it. If it's not current, then it will sit on the shelf until your priority date becomes current, and you'll just continue using your AP EAD, which you can renew even if you're in a backlog. For those of you who are outside the US, it's important to file sooner rather than later, so you can, of course, secure an earlier priority date, which means you're just earlier on in the line. But it's really going to be important to look at the visa bulletin once your I-526E has been approved. If it's been approved and your priority date has been current, then your attorney can push the National Visa Center to at least get them to issue that visa fee bill so that you can pay that visa fee bill, unlock the DS-260, and try to move through the process quickly.
Exactly. So other than for investors in the US, it's about being able to adjust status, whether either Chart A is current or whether you're current on Chart A or whether Chart B is available to you, then you can concurrent file. But the main backlog is after you've received your I-526E approval, there's not a visa available for you to have your 485 approved or to go through consular processing until your priority date is current. So it's after the I-526E gets approved, that's when your child's age unfreezes. That's when they have the risk of aging out. And that's where the wait is for the green card.
And just so everyone knows, theoretically, USCIS and the State Department have come out and said that they take a visa availability approach, which means that they should be, your I-526E should be pending the entire time until a visa becomes available. But like Brennan says, sometimes they do approve it earlier, and it's really between that gap between I-526E approval and a visa becoming available is what we need to pay attention to.
All right. So there are some good questions in here saying, asking about if I file, let's say I file a petition in March of 2025. And at that time, I'm allowed to do concurrent filing. It's not backlogged on the visa bulletin. But then let's say in July, they issue a priority date, and that priority date is March or December of 2024. Is that going to impact the concurrent filing that I did?
No, as long as you concurrently file before any kind of backlog or final action date. Because I think part of it is when we talk about concurrent filing, and from talks with many of you, I think one of the main goals, one of the main focus is to take back some sort of like predictability, some sort of control over the immigration process. So if you have concurrently filed before any kind of backlog, your EAD and your AP will continue to be processed as normal. Even if there's a backlog in the future, you can extend it as many times as you need necessary. So your work, your employment, your travel, your ability to be in the US is uninterrupted. So I think that's a very good question, and that's important to remember.
Well, I think that's huge. I think that's what everybody's looking for here is how much time do I have? And the answer really in the high unemployment category, you can see that the demand significantly out supplies or outweighs the supply of visas over the next couple of years. But in rural, it's right at kind of equal. The demand and the supply are kind of equal. It's going to take time for these to show up on these priority dates to show up on the visa bulletin. What the USCIS is saying is that it's probably going to show up before September 30th. So there is time to get in. There is time to concurrent file. And as long as you concurrent file, even if there is a significant backlog that does arise for you at some point, you're going to be able to concurrent file and get your EAD work authorization and your advanced parole travel permit. And so but what that's going to do, as Phoung mentioned, is that is going to cause a huge rush. There is going to be, we've seen this happen. I remember when they first started talking about this at the IIUSA event. I remember in April of 2015, I was in DC at the IIUSA event. It was right when China had first shown a priority date and people were freaking out, didn't really know what to do. But what happened was there was still a mass rush of filings, and there's going to be before a priority date is shown, and there's going to be after a priority date is shown. So there's going to be a ton of petitions filed this year. So what really is the next steps for you as an investor who wants to do this? Well, the thing that's most important is that with every one of these projects that's out there in the market, whether it's an EB-5 United project or one of our competitors, you can invest in any one of those projects, no matter which EB-5 immigration attorney you utilize. The source of funds is done completely separately from us. So whatever project you're going to end up choosing, that doesn't really matter. It's about being able to file that petition. And that takes an immigration attorney. And there is a limited number of good immigration attorneys that understand the EB-5 program. And when there is a huge rush of investors coming in at a time like this, where there's an impending priority date, and then once the priority date is posted, the backlog's not going to be too huge to start off with, but it will grow quickly. So there's still going to be a big rush. The thing that you have to do is have an immigration attorney already hired and on your side working for you, because all of them are going to be booked out, and it's going to be hard to find somebody to give you attention to look at your case. So I guess I'll throw it back to Phoung and Niral, just like what do you recommend to investors that are seeing this and scared and trying to figure out what they need to do? What do they need to do to prepare for this?
Yeah, I mean, I think part of it is the scenario you laid out, Brennan. And even though, I know you've warned folks and we have warned them that, there's possible backlog and they should be prepared. Invariably, there's going to be that last minute wave, that rush of people coming through, right? But I think despite all this news and despite this possibility of a backlog, there's just practical steps you can take to kind of prepare yourself and protect yourself. Part of it is like, imagine if before you knew about this EB-2 and EB-3 backlog, that you could take steps to protect your status, right? To make sure that you could always work, to make sure that your family could stay protected, which is what we're doing now. Anyone that goes through the EB-5 process, and we have always advised this, backlog or not, we think it makes the most sense to begin working on your source of funds right away. Source of funds will usually take the longest for most investors. It's almost like buying a house, right? So before you buy a house, you want to make sure you're pre-approved for a loan, you know where your money is lined up. That way you can freely you can spend your time looking at which house or which building to buy. And when you're ready to make that decision, you know your money is ready. That allows you to not stress out and just have to buy something that you see at the first possible step. So I think it makes sense to work on a source of funds, figure out what's a practical partial funding strategy. And then in the meantime, you can spend that time to review different projects that might suit you.
Yeah, and I think just to add to what Phoung said is, I think it's also important just to remain calm as possible, right? I mean, of course, it's a big financial commitment, and you hear about retrogression, and a lot of you in the EB-2, EB-3 backline, it does sound scary. But I think it's also important to rely on the experts that you choose to work with on both the attorney side and the project side, who will, I'm guessing, they'll give you unbiased and unsubstantiated information and advice, and like Phoung said, practical advice. We'll walk you through exactly what you need to do and when you need to do it to protect your child's age, make sure that we file in a timely manner with the strongest possible case. So we're not looking at denials or rejections. We're just looking at practical steps that you can take to protect your ability to work and travel freely when that APAD comes in as well. And I think it's also important to note, right, that before you could only be repaid once you went through the entire immigration process and you got to that 829 stage. So if you were caught up in a backlog, then you may have had to wait 7, 8 years or whatever it is. Now that immigration has decoupled repayment from your immigration timeline, it's also important to know that you're not now wondering when am I going to get my money back. There's also a lot more predictability to when you're getting your money back, no matter where you are in the immigration timeline as well.
I think what Niral brought up is a huge point, an important point. We know this information about the possible backlogs, but there are definitive steps that you can take to, I mean, just think about this as a working professional or as a family person, right? You can take definitive steps to ensure that your life is uninterrupted. So I've had talks with some clients or some investors during the course of the few weeks when this news came out. And one of the takeaways they understood was, even if there is a possible backlog in the future, but I file now and I can extend my EAD forever, work wherever I need to work, and travel wherever I travel. My kids can go to school. They can apply to college like normal. During this whole entire process, even though I don't have my green card yet, I could still get paid back before I even complete the process. That's not such a bad deal then. All the benefits of a green card plus your money back as long as you file before any sort of backlog. So all those things, all those options are still in play.
Well, and from listening to both of you guys, I think just preparation for this is the best way to mitigate the problem. Having an immigration attorney hired and starting the process as a source of funds right away, because there's going to be a month, let's say it's July, that they post a priority date for August. There's going to be a month that concurrent filing ends. So let's say that's July, or that might not even happen until 2026, who knows? But if it's July and they say, okay, on August 1st, there's going to be a priority date, they'll post that around July 10th. And there's going to be a 20-day window where every single person in the US trying to do EB-5 is going to try to file their petition. And if you don't have an immigration attorney hired, it is unlikely that you're going to be able to find one who's going to have the time to put into your case to get it filed by that August 1st. So that's a huge thing. And one other thing that this is going to cause that I'd like to ask you guys about, a lot of people are going to want to get a partial payment in and file as quickly as possible. Now, what people are asking, when does my money need to all get in? When does my 2-year sustainment period start? Obviously, that's not till fully funded. So what risks are there with doing partials? And by when do I need to get the funds in? Because there's also, the issues of RFEs, especially with priority processing, they're coming quick. I guess that's a question for you, Niral and Phoung.
I mean, I think, carry on, Phoung.
I think in terms of partial investments and everything else, for our firm, it's become pretty much a fact of life. It's how I think the vast majority of investors, probably since 2015, 2016 to now, the majority of them have done partial investments, and you do it for a number of reasons. You do it because, not everyone just has $800,000 in a safe lying around. A lot of you probably have your wealth tied up in different assets, RSUs or equity or, in different things. So it's partial investments are necessary for immigration, but also in terms of financial and tax planning. So we've gone through this process so many times now. And I think part of the other thing is, if you're going to hire an attorney, you want them to not only be able to handle a partial investment, but finish in time, be up against a backlog. One of the other things that I think our firm does during these sort of rushes is that, for example, even if there's 3 weeks left, we would rather you not invest in a terrible project like what Brennan is highlighting here. We still want you to make a sound investment decision. So there are things that we can do to help our investors as long as you communicate. If you reach out to Brennan and EB-5 United, for example, and we tell them that, look, if we start this case, we will get it through the door within 3 weeks. Brennan knows from personal experience that we will meet that deadline. So, we sit down, we figure out what's realistic to fund within these 2-3 weeks. And the other part is we want to see what other assets you have in order to fill out the rest of your investment. In terms of when you have to be fully funded, that's both a decision between you and whatever project you're investing in, and also how how fast USCIS will process your case. If we generally tell people 6 to 8 months is a good ballpark, but if it's a rural project, it might be faster. So if your case gets picked up within 3 months, you have to be prepared to fund, basically. If we do this correctly, the goal is that by the time USCIS ever picks up your case, there's actually no distinction between a partial and a full investment, because we would have supplemented already. When they pick up your case, they will basically see a full investment and should be able to approve. So all these things are taken into consideration. These are factors that we work with. And so long as we do that, the case will be approved.
Well, and I guess the last piece to that is also your 2-year sustainment period that the money has to be in the project isn't going to start until you have fully funded. And so, partial funding is a good way to get your case in early and to try to be able to concurrent file. However, it's not just a way to withhold capital and say, oh, I'm going to keep this invested in the market while I put up half the money and then I'm going to pay the other half in 3 months and just leave this here. It's for people who are really, they don't have the funds liquid. They need another 2 to 3 months to maybe close on a HELOC or sell a home or do what they need to do, but they can source all the funds up front. They can get the petition filed and they can get all the rest of the money in. You mentioned the 6 to 8 months is kind of a tops that you would want to see. But yeah, I mean, even in rural, most filings are picked up within 3 months by USCIS, by the adjudicators. And so if you haven't fully funded within about 3-4 months, there's a high likelihood that you're going to receive an RFE as well on that, asking for proof of funding. And once you receive that, now you're on a clock to being able to fully fund. So it's not something that necessarily you're looking at, okay, I'm going to partial fund and fund just a year later. It's something that you really need to be in the process of fully funding. But hey, I want to get my petition in as quickly as possible. I want to have the earliest priority date. And let's go ahead and use this option.
All right. That's why when we do partial filings, I think it's important to explain that you are in the process of investing, how much. And for all investors, we also identify look, not only are they in the process of investing and they funded this amount, they have the ability to fund the remaining amount from these sources right now. They just need to be able to liquidate them in a short amount of time. So with our partial filings, we also give USCIS an indication of if this investor had to fund within the next month or 3 months, these are potential sources that it would draw from. It's not something that you want to figure out later on. There should be a clear game plan. This is the partial investment, and this is the remaining amount that needs to be invested in the future, and this is why it works out. So none of that should be a surprise.
Well, and I think in a grand summary of this, what we really know at this point from the data is that demand is reaching supply in the rural category. Demand outpaced supply in the urban TEA category, and that these priority dates are coming. However, how long the backlog will be is very difficult. It's very difficult to put a number on. It's very difficult to say because it really depends on how fast your petition gets adjudicated and you get to the next step that you could get in and get a visa before your priority date backlogs. So there's a lot of nuance to that. It's very unclear. The only thing that we are clear on and that we can control, for you as investors is hiring an immigration attorney and getting through the process and filing a petition with the earliest priority date possible. I mean, that is really the only thing that you can control as a petitioner to try to get in and be able to concurrent file or trying to get in and, secure your family's future if you have kids that are in their late teens, and try to avoid this backlog. So there's going to be a lot of demand. For us, just quick plug at EB-5 United. We've raised more than $1 billion through the EB-5 program over the last 15 years. Of all the rural filings, this was as of September 11th this year, we had filed about 55% of all the rural filings in the industry since the RIA passed. This is more than our top 11 competitors. And so we have projects available. We're not going through those today, but if you're interested in any of those, again, reach out to me and I'll get you connected with a sales rep for your area. Any last words, Niral and Phoung?
I think just get in touch with your experts, get in touch with your attorneys, projects. And if you're serious about doing this, you want to just do this sooner rather than later.
All right.
Yeah, you don't have to be worried. You don't have to start freaking out over this information. I think there can be a measured, deliberate process of how you handle it, right? There's definitely a way to make this not stressful and get what you want and ignore all the noise about the backlog. And I think that's probably the best way to approach it.
All right. Just a couple more questions just to answer briefly. One, if I have a EAD, advanced parole, can my kid, and I'm living in the US with my kids, can my kids apply to schools or work in the US?
Yes, yes. And for your kids going to college, for some colleges that if you're trying to pay in-state tuition, pending adjustment of status will allow them to qualify for in-state tuition. It's like a third less, right? So it's to your benefit as well. So yes.
I think we covered the partial investment here, covered some of these other things about, timing of the backlog is just difficult to say. There's so many different variables. And then last thing here, what happens to set aside visas when the RIA is set up for renewal in 2027? That's really unclear. The two dates that we have are September 30th of 2026 is when the grandfathering ends. So as long as you file before September 30th of 2026, the USCIS has to adjudicate your petition. But September 30th, 2027, the USCIS will have to extend the program. Congress will have to extend the program. And there'll likely be another bill at that time. Well, I think that wraps it up. I hope this was informational for all. We'll put out a recording of this as well. And it was great. Thank you for attending. If you have further questions, please reach out to us.